This is Bloomberg Law with June Grasso from Bloomberg Radio.
In a 7-2 decision, the Supreme Court today upheld the federal regulation of build-at-home ghost gun kits. The decision keeps in force a 2022 rule put in place during the Biden administration that subjects commercially sold gun kits to the same requirements as fully assembled firearms, requiring serial numbers and background checks. Joining me is Bloomberg Supreme Court reporter Greg Stohr. Greg, this wasn't a Second Amendment case. What was the issue here?
The issue is whether federal regulators, in particular the Bureau of Alcohol, Tobacco, Firearms, and Explosives, had the authority to regulate these so-called ghost gun kits under the existing gun laws. So the existing gun laws give the government power to put regulations like background checks, things like that, on fully assembled firearms. And the question is, well, what if they're not fully assembled?
And Justice Neil Gorsuch wrote for the majority, the 7 justices in the majority. What was the basis of his opinion?
Yeah, so it was a pretty technical opinion. He's very much a textualist, likes to look at the text of the law. And so he looked at the text of the 1968 Gun Control Act, and he said that the regulation that ATF had put in place to regulate these kits met within the definition of a firearm in that 1968 law.
Not surprising, there were dissents from Clarence Thomas and Samuel Alito.
Yeah, so at least on the surface, they were mostly focused on the language, and Justice Thomas disagreed with Justice Gorsuch on what that 1968 law allows. Justice Thomas, his dissent was 26 pages, so it too was very, very technical. Justice Alito added his own dissent that was a bit shorter and sort of focused on some of the procedural aspects of the case, including criticism that the way the court decided the case as a so-called facial challenge to this regulation wasn't exactly the way it was argued.
So is a ruling in favor of gun regulations from this court a surprise to any extent?
It is perhaps a mild surprise. The argument suggested this might be the outcome. But if you go back just a term ago, a similar kind of argument, again, having to do with statutory interpretation, not the Second Amendment, the court struck down the Trump administration's ban on so-called bump stocks, those devices that convert a semi-automatic weapon into something akin to a machine gun. So that decision perhaps boded poorly for this, to the extent both were actually focused on the extent of the federal government's authority over to regulate guns. But there are different statutes and different provisions, and so the cases came out differently.
It was also a bit surprising considering that the court has been so skeptical in the last couple of years of administrative agency powers. And I would say particularly Justice Gorsuch.
Yes, he has been. And certainly, if you look at that big decision from last term where the court said we're no longer going to defer to agencies on the meaning of ambiguous statutes, that sort of thing does suggest that, the court isn't going to let agencies have their way in cases like this. But again, this is about this particular statute. And looking at the words of this statute, a majority of the court said that, just because a kit isn't fully assembled, if it still has the components of a firearm, that's enough.
Do we know how the Trump administration is going to handle this? Because this is a rule from the Biden administration, and he signed an order requiring the AG to review gun regulations. So is it sort of up in the air?
Yeah, that's a really good point, and we don't know. Yes, indeed, it is up in the air. The Trump administration didn't take a position on this. The challengers to this regulation have called on the Attorney General Pam Bondi to take another look at this issue and toss out the regulation. And the Justice Department, when I asked them for comment, has just said, we support people's Second Amendment rights, which, of course, isn't what this case is about. So we really don't know what they're going to do.
This was a reversal of the Fifth Circuit, the most conservative circuit in the country. And the oral arguments today regarding the FCC may also result in an overturning of the Fifth Circuit.
It might well. The arguments today are about this program known as the Universal Service Fund, which is a program, $8 billion program run by the FCC that imposes a charge on your phone bill and uses that money to subsidize phone and internet service for poor people, folks who live in rural areas, schools, libraries, rural hospitals, things like that. And it was a constitutional challenge saying that essentially the core of it was that Congress had delegated too much of its authority, too much of its taxing authority to the FCC to determine how big this fee is on your phone bill. And based on the argument today, it sounds like the Supreme Court isn't buying that, and they are going to uphold this program.
That would be another win for a federal agency in this term. I'm keeping track. I'm also trying to keep track of the Justice Department fast-tracking cases over Trump's efforts to push the boundaries of executive power. Because today they asked for the Supreme Court to intervene in a case. They had already asked for the Supreme Court to intervene in another case on Monday. These are all being done on an emergency basis. Are they up to about 6 emergency requests in a little over 2 months?
By my count, it's 5 times. What they're asking for this week, well, the most recent case has to do with teacher training programs. So the Trump administration is asking the Supreme Court to lift a lower court order, a district judge's order, that temporarily requires the government, the education department, to keep funding teacher training projects in 8 states. The education department had said that it's canceling 104 out of 109 grants. A U.S. district judge said that the challengers to that are likely to succeed, that the cancellations are arbitrary and capricious, and so that judge issued a temporary restraining order saying you got to keep paying those for now. And the Trump administration is now here asking the Supreme Court to lift that order so they can freeze those payments. The one earlier in the week, on Monday, had to do with efforts to fire a number of people in 6 different federal agencies. And the Justice Department is asking the Supreme Court to let it go ahead and fire those people, or at least not actually bring them back to the workplace, at least to just put them on administrative leave. This is a case out of California that is similar to another one in Maryland. The Supreme Court so far has not done anything with that one, and I say that they haven't even asked for a response from the nonprofit groups that are challenging this. And it may be that the Supreme Court in that case wants to hold its fire because there's actually something still pending before the Ninth Circuit in that case. So a lot of stuff going on here.
Are the justices perhaps getting numb to these emergency requests? You say 5 in a little over 2 months. I mean, has any other administration made so many emergency requests to the court in such a short period of time? And they're calling issues like birthright citizenship an emergency.
Certainly, we've never seen anything like this. And, of course, we've never seen anything like the flurry of Trump executive orders that sparked an awful lot of this. The one thing I would say about the Supreme Court so far is it's pretty clear they are in no rush to get involved. The way they have handled cases up until now has been to sort of kick the can down the road. And I think we see that with, you mentioned birthright citizenship. That's a case where the administration came here and said, hey, we need an emergency order, at least limiting these lower court injunctions so that we can impose our new birthright citizenship restrictions in much of the country. The administration said we need an emergency order. And then the Supreme Court gave an unusually long time for the folks on the other side to file a response, gave them 3 weeks. And that comes on top of some earlier stuff that really indicated the court did not want to dive into these very contentious issues until it absolutely has to.
One thing is certain, Greg, you are going to be very, very busy over the next few years. Thanks so much for joining me tonight. That's Bloomberg Supreme Court reporter Greg Stohr.
While our journeys in life are all slightly different, my DNA journey started here with 23andMe, and it was all so simple.
It may have been simple then, but it's getting complicated now as 23andMe filed for bankruptcy, raising concerns about the future use of the genetic data it's collected from more than 15 million customers. The laws provide very little protection for customers, and any future buyer of the trove of genetic data will likely have the last say on how they use it. My guest is Collin Walke, a partner at Hall Estill and leader of the firm's cybersecurity and data privacy practice. Before we even get to what's happening now, in September, the company agreed to pay $30 million to settle a class action lawsuit for a data breach that affected 6.9 million of its users. Has a lot of their information already been compromised?
Yes. And so here's the concerning part about the statistic you just gave about the data breach. That data breach affected roughly 6 million individuals. However, the vast majority of those individuals were of Ashkenazi Jewish descent or Chinese descent, meaning that it appears to have been a targeted attack in order to identify who is of Ashkenazi heritage or who is of Chinese heritage. And so, yes, those 6 million individuals' information is certainly out there somewhere. The remaining people, who knows?
23andMe is in bankruptcy. So is all the information it has, all the personal and genetic information, going to be sold with the company?
Well, that's the plan as of right now, is that they are looking for a buyer of that. And here's the reality, is that our data is an asset. And that's why it's bought and sold with data brokers and, openly traded. And so the consequence is those assets have value. Our data has value. And so, yes, the plan is that in the bankruptcy proceedings, either 23andMe gets bought out as a whole entity, or perhaps the assets themselves get purchased, and then only the assets survive bankruptcy, not the entity itself.
So the board chair issued a statement saying that 23andMe is committed to continuing to safeguard customer data and being transparent about the management of user data going forward. Quote, any buyer of 23andMe will be required to comply with applicable law with respect to the treatment of customer data. What does that really mean?
Not a lot in today's world. And the reason is, as everyone's been discussing, there really isn't a federal law that governs this sort of circumstance. Even though we're talking about health information, HIPAA is not applicable because 23andMe is not what's called a covered entity. 23andMe is not required to abide by HIPAA rules and regulations. Then you have to ask yourself, okay, well, what are the state requirements? And at the state requirements, first and foremost, not every single state has a data privacy law. So, for example, in Oklahoma, I literally have no right to my data that may be housed within 23andMe. There is no law that compels them to do anything that I ask them to do. And if I lived in a state, for example, like California, I don't necessarily have to give my consent in advance for the collection of my sensitive information. Versus a state like Colorado, I do have to give my affirmative consent for the collection of my sensitive data. But it then begs the question, if 23andMe is purchased, do I have to give my consent again? And here's the other really, truly concerning part about 23andMe's statement. The biggest concern has to do with, for example, their terms of service, which they state can be changed at any time. And the same thing applies to their medical record privacy notice, which they say may change from time to time. And so for an individual to come out and say that 23andMe is still going to continue to comply with the law, it begs the question, which law? Because in certain circumstances, there aren't any laws that govern how they can use our data.
Tell us a few ways in which this data could be used against customers in the future.
So the biggest concern right now has to do with deepfakes. And we all know about AI technology and those sorts of things. And if an individual is able to identify someone's family tree through the genetic information that's been held by 23andMe, then that individual has a better ability to do a deepfake. Not only do I know your name, your address, and social security number, but I now know your entire family tree. And so this type of information can be used for what we call synthetic fraud, where there's a real human being that is utilizing fake information. That's one of the major concerns. Another major concern, again, going back to targeted hacks and AI, if you think back to the hacking of 23andMe in which the 6 million records were lost, they are identifying individuals with particular racial traits. So we have to be concerned not just about bad actors who have this information, but even, quote unquote, good actors like insurance companies, healthcare providers, schools, any type of governmental agency or private agency If they're wanting to evaluate you as a human being for creditworthiness, to get a house, to get a loan, one of the things they may look to is your genetic information and your genetic data. Do you have, for example, genes that might lead you to get Alzheimer's? Do you have genes that will lead to some sort of disease that in the future is going to cost an insurance company a ton of money, and therefore they decline to insure you based solely off of this genetic information? So there's a lot of discriminatory aspects to this, as well as targeted phishing attacks that can result from someone acquiring this data and information.
So attorneys general in California, New York, Georgia, North Carolina, Virginia, and Florida have sent out alerts warning that customers' data could be sold in the proceedings and advising customers to delete their accounts and ask for their genetic samples back. So doing that, would that cure the problem that customers may face when the information is sold?
I would say that it certainly goes a very long way, because if you have asked for them to delete their data, and again, they're obligated either through their own contractual obligations or a state law to delete that data, that certainly goes a long way. One of the questions, though, that is begged is how they actually store that data and that information. So, for example, they may get Collin Walke's genetic information because I voluntarily supplied it, and then they stored it in what we call an anonymized, or to be more accurate, pseudonymized fashion. And what that means is they block out all of Collin's PHI, identifiers to link back to Collin Walke directly, and then you just have a data set sitting there. The question then is, if I have another data set that doesn't have genetic information, right, but might have a zip code or an address or something along those lines, can I relink that data back to Collin Walke specifically? And that's something we don't know. So you may have your information deleted, but on their servers, they still retain a copy that is, for all intents and purposes, anonymized. You look at it, you can't see anything. But if you link it to another data set that might have some additional information, you could potentially re-identify individuals. So it certainly goes a long way. It may not cure the entire problem, but it's certainly the first and best step to take.
Most states have health information exchanges. Do people have to worry about that as well?
That's a very interesting question. I'm glad you brought that up, because health information exchanges are governed by HIPAA. The problem, however, is that many, if not most, if not all, are actually owned by third parties, right? And so, for example, Idaho's HIE a few years ago declared Chapter 11 bankruptcy. And they fortunately worked out a plan, but they were kind of in 23andMe's situation. And for individuals who don't know what an HIE is, it is a database where every time you go to see your doctor, your healthcare information is uploaded into this HIE. And in theory, this is good, because in theory, that means that if you're in one part of the state where your primary care provider is not, and you get into an accident, well, whoever's taking care of you just logs into the HIE and is able to determine whether or not you have any sort of medical conditions or reactions or something like that, even though they've never treated you. The problem, however, is it increases the threat surface for individuals to do cyber attacks. And if you have all 4 million Oklahomans' information sitting in an HIE database, that's a very valuable database to get a hold of. And so HIEs have a little bit more protection for consumers because of the HIPAA compliance requirements, but they're just as dangerous because they're being held by third parties that are susceptible to hacks just like everybody else.
So 23andMe has proposed a May 14th auction to sell its assets. Will the bankruptcy court be monitoring any aspects of the sale of the genetic data?
That depends. I could certainly see a situation in which, as part of the deal, an agreement is reached to comply with some sort of privacy law, whether that be HIPAA or otherwise, and that the court signs off on. However, I don't know that a court can unilaterally make that decision and say, you're going to treat the data this way. However, if 23andMe is serious about them abiding by the law and that they're going to do everything above board, then there ought to be an agreement to enter into a judicial order as to how these assets are going to be transferred and dealt with in the future. But absent an agreement, I don't know that the court has the authority to then order them to do certain things with that healthcare data other than comply with state law.
After the assets are sold to a different company, could the FTC step in or state attorneys general to monitor what's happening?
Yes, I absolutely think so. Part of the problem with the state attorney general approach is just funding, right? I mean, if you think about how many tech companies are out there and trying to make sure they're complying with privacy regulations, well, I mean, good luck, right? I mean, we understand that's going to be a huge, heavy load. But the flip side of that coin is they still have to comply with the laws. The question, though, is how? So, for example, in Colorado, you have to get consent in order to process sensitive data such as your genetic information. Okay, 23andMe got that consent. And now I've purchased 23andMe. Do I have to get that consent again? It's still the same entity. Probably not. If I just buy the asset, just buy the genetic information, well, maybe then I do have to get consent to utilize and further process that data. That's kind of an unknown at this stage. But I certainly think that the AGs will have scrutiny, especially over anyone who purchases this. But again, out of the 26 million people's information that's in that data set, do tell me how many of them live in states or countries with data privacy laws.
So let's say someone is still interested in genetic testing. Is there anything that they can do if they decide to sign up with one of these companies? Is there anything they can do to protect their data?
No, because once you transfer your data into the hands of a third party, absent regulation, they're free to do whatever the heck they want to with that data. It is truly the Wild West, which is why Congress and the states need to get serious about enforcement, because the reality is even the laws on the books are not very strong laws. Every single law on the books is what's called opt-out, which means that unless you tell them don't collect and sell my information, that's what they're doing. And so here, yes, we're dealing with sensitive information, but aside from Colorado and a few other handful of states, there's no rules on what individuals have to do. Just like Fitbit. How many people wear Fitbit and are sharing their sensitive biomedical information with Fitbit? Millions of people are doing this on a daily basis. And I don't think that people appreciate the harm and the exposures that come from that type of, to be frank, cavalier behavior. I appreciate that we all have, an interest in our history and our family trees and those sorts of things, but I strongly encourage individuals to be careful with that type of data, to be frank with any of their data. But since we're talking 23andMe, especially the genetic data, because unlike your Social Security number, unlike your name, unlike pretty much everything else about you, you cannot change your genetics. And if somebody gets a hold of that information, that is something that is immutable and cannot be changed.
So this may end up being a sort of wake-up call for people.
I'm afraid that we have gotten to the point in our country where we care more about convenience than we do about our personal safety. And we see that all the time with the apps that we download and those sorts of things. And I don't think that individuals appreciate how susceptible that makes them to both personal, physical, and financial harms. And so anybody that's listening to this, whether it's 23andMe or wearing a Fitbit, I strongly encourage you to rethink whether you truly need that information, because it is being bought, sold, and bartered on the open market without your knowledge or consent, and all of it is being bought, sold, and bartered in order to exploit you and pilfer your privacy for profit. So this is a day and age that people need to wake up and realize we're being exploited and we need to take control.
This case certainly raises a lot of concerns. Thanks so much for being on the show, Collin. That's Collin Walke, a partner at Hall Estill. A North Dakota jury has found the environmental group Greenpeace liable for defamation, conspiracy, and other claims over its participation in the Dakota Access Pipeline protests that lasted from 2016 to 2017. The jury awarded the pipeline company, Energy Transfer, $660 million in damages. Greenpeace says it will appeal, and environmentalists warn that the verdict could chill free speech. Joining me is environmental law professor Pat Parenteau of the Vermont Law and Graduate School. Pat, give us the background of this case.
So this was one of the largest protests of a fossil fuel infrastructure project, Dakota Access Pipeline, in the nation's history. In fact, it drew well over, I think it was 400 tribes, not only from the United States, but from Canada, from Mexico, and from other countries. It was a massive protest, and the concern was the impact of the pipeline on the Standing Rock Sioux tribe's water supply. The pipeline was going to go across the Missouri River right above the intake for their water supply. That's the thing that originally motivated the protest, and then all these other tribes joined with the Standing Rock tribe in solidarity. And Standing Rock reached out to Greenpeace for help in, figuring out how do we conduct a protest, a demonstration that doesn't run afoul of the law, or at least understand where are the lines that we shouldn't cross. And Greenpeace agreed to provide that training on civil disobedience. They provided some money, I think about $15,000. They provided solar panels to provide some power to the encampment because, they erected tents. They occupied the area where the pipeline was being built. There's allegations that they actually encroached on the right-of-way that's part of Energy Transfer's property. And, that gets into the whole trespass issue. So it was a multi-year, massive protest. There was violence. There were incidents where the security firm hired by Energy Transfer got into confrontations with the protesters, not so much with Greenpeace itself, but with tribal members and other people that showed up in support of the tribe. There was incidents of damage to equipment and so forth. So, that's the backdrop to the case.
So Energy Transfer, the pipeline company, sued Greenpeace for defamation, trespass, nuisance, civil conspiracy, and other acts. During the trial, the company's attorney argued that Greenpeace had paid outsiders to come into the area and protest, sent blockade supplies, organized or led protester trainings, and made untrue statements about the project. The jury's verdict on the defamation claims are what many people have been focusing on in this case.
Yeah, that's the central claim and the one that probably resulted in the largest award. I mean, this was a astronomical verdict, $667 million against three Greenpeace entities, Greenpeace USA, Greenpeace Fund, and Greenpeace International. The lion's share of the damage is awarded against Greenpeace USA, and obviously an amount like that would, if it was upheld on appeal, would bankrupt many times over Greenpeace, even though Greenpeace is a major organization. So defamation was the heart of it, and it came down to 9 statements. Of course, to prove a defamation case, you have to show that the defendant, in this case Greenpeace, made statements that were published to a third party. And obviously Greenpeace had it on their website and in press releases, and so there was broad distribution. So you have to have a materially false statement. That's the key. It's got to be false, and it's got to be material that actually causes damage. And because Energy Transfer is considered a public entity, because it's a sort of a high-profile company, under New York Times versus Sullivan, you have to prove actual malice. So not only that the statements are false, materially false, but that they were made with actual malice or reckless disregard of the truth and the consequences to the reputation of Energy Transfer. So these are really, really high standards that you have to meet for a defamation case. And here's the real kicker. If the statements in question, even if they were false, were privileged in any way, and there are a variety of privileges, the most important of which, of course, is the First Amendment to the United States Constitution. The right of free speech, the right of assembly, the right of petitioning government, the right to object and oppose projects that you disapprove of, for whatever reason. Opinion can't be the subject of a defamation action, and protected speech cannot be the subject of an action for damages. Where it gets tricky, of course, is what's protected speech versus what's defamation. In this case, because all the statements in question were written, the underlying legal doctrine is libel. So it's a kind of a stew pot of different issues and factors that go into calculating, was this protected speech? If not, was it materially false? Did Greenpeace know it was false? And did Greenpeace with malice make a materially false statement? The jury, in this case, agreed with Energy Transfer.
What was Greenpeace's defense? That it was true, that it wasn't malicious, that it didn't meet the standard?
All of that. The key one that really crystallizes the crux of this case has to do with the following scenario. The pipeline was crossing historic Sioux Nation lands. Of course, these lands have since been transferred by a variety of mechanisms, some of which have been found to be illegal, to private ownership, including Energy Transfer's ownership of the right-of-way. So in crossing these traditionally native lands, the tribal historic preservation officer, this is an official position. It's recognized under federal law, under the National Historic Preservation Act, and it exists to review projects that require federal permits, and the pipeline does require federal permits, including a permit from the Corps of Engineers for the crossing of the Missouri River with the pipeline. So the tribal historic preservation officer said, whoa, Energy Transfer, you're crossing areas that have native graves. We don't know exactly where they are, but we know from our tradition, both oral and written, that these areas were occupied by our people, that people were buried there. And we also know that some of the areas that you're crossing have historic archaeological remains that are protected under federal law. So stop the construction so that we can do a careful inventory of where these cultural resources might be and what needs to be done to either avoid them, ideally, or mitigate, recover them and protect them. Within days of the communication from the Tribal Historic Preservation Officer, Energy Transfer sent the bulldozers out and bulldozed the right-of-way. So Greenpeace made 9 specific statements that the court identified as the source of defamation. By my count, I looked at them. 4 of them dealt with this specific instance of bulldozing these cultural resources. So it appeared to me, and of course I wasn't in the courtroom. In fact, the court refused to televise the trial, even though, live streaming of trials in North Dakota is allowed. So by my, understanding, it's true that Energy Transfer sent the bulldozers in after they were told not to do it. So at a minimum, you have to say, did Greenpeace, relying on the tribe's historic preservation officer, knowingly make a false statement? They could have been wrong about that, but they were relying on the information they were being given by the tribe. And secondly, even if they were negligent, that's not enough in a case like this. You have to show actual malice, not just negligence. So in addition to being deliberate, you have to say they did it just to be malicious. And that's pretty hard to prove.
Of course, since neither of us were in the courtroom during the course of the trial, we don't know what evidence the jury saw, but it was enough to make them come back with a whopping verdict against Greenpeace. So Greenpeace says it's going to appeal, but one wonders what its chances are on appeal.
I'm sure they're thinking positively, but they can't be sanguine about it. Because here's another point. Greenpeace obviously moved to transfer this case. This case was being heard in Mandan, right in the middle of where the protests were occurring. In the voir dire, process of questioning the jurors, it came out that there are 9 jurors in this particular case. Most of them had some connection to the oil and gas industry. Either they worked for them or family members worked for them. This comes out in questioning, right? Or they have some kind of economic interest in what's going on. This is a major, backbone of the economy of this part of North Dakota. This is the Bakken, where all of this crude oil is that's been exported. So you have the fact that the people on the panel, on the jury, had to live with these protests for almost 2 years. That couldn't have been an enjoyable experience, right? Thousands of people occupying their community and protesting. So, the sensible thing would have been to transfer the case to Fargo, take it all the way almost to Minnesota, right? Get it out of the community that was most affected. But that was refused all the way up to the North Dakota Supreme Court, which refused to transfer the case. So that tells me, you're not going into a particularly friendly forum with this appeal. Lots of grounds for the appeal, for sure. Rulings on evidence in the case that went against Greenpeace and in favor of Energy Transfer. Jury instructions that did not call out the First Amendment issues at all. I looked at them. It didn't instruct the jury on what exactly is protected speech. That's actually a question that the court itself should have decided. But certainly the jury can't be left to wonder, is what was said here actually protected by our U.S. Constitution? So lots of ground for appeal.
Would paying this verdict really bankrupt Greenpeace?
Oh, many times over. I mean, it's a major organization, but it doesn't have $667 million lying around. And even if it's cut in half, it's going to bankrupt them. This is a high-stakes case, not just for Greenpeace, but obviously the implications here, the chilling effect of this kind of verdict I mean, if you were an NGO, would you seriously consider protesting and demonstrating against fossil fuel industry after this? Boy, you'd have to think long and hard about that, wouldn't you? I mean, would you put your entire organization at risk, even if you're an Audubon Society or National Wildlife Federation? They can't afford to risk a judgment like this. And just the cost of litigation. Again, 2 different lawsuits that Greenpeace has had to defend. Just the cost of that alone is something that most organizations couldn't absorb. They did have some pro bono help in the case, or they probably couldn't have mounted a defense at all. But I think the chilling effect of this magnitude of verdict is hard to measure, but potentially seismic.
Thanks, Pat. That's Professor Pat Parenteau of the Vermont Law and Graduate School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.